you, Haneen, for inviting me to do this webinar. It's my pleasure to be here, I guess, in my own home and in your own home. But before I start, I wanted to talk to you a little bit about myself. So again, my name is Mary. I was born and raised in Texas. I currently live in Millbrae, California, where I was a school teacher here in Millbrae for over 10 years. I taught first grade, second grade, fourth and fifth, and none of that has prepared me for the shelter-in-place teaching at home. I got my JD from Golden Gate School of Law. I'm currently back at Golden Gate getting my LLM, which is a Master's in Estate Planning. I've also worked at the San Francisco Attorney's Office in their Children and Family Services Division, and I'm a mother of twins, twin boys. They'll be starting kindergarten next year. So today I'm going to describe what estate planning is and some reasons for doing it. I'm going to go over some common estate planning options along with their advantages and disadvantages. And I'm also going to talk about how estate planning is not just having a will or a trust, but what are also some other foundational documents that you should include in your estate plan. In order to discuss estate planning, we need to first define what is your estate. Your estate includes things you own. So this could be your real estate, like your home and investment property, assets, like personal property, including your automobiles, jewelry, art collections, antiques. It includes your investments, like your IRA accounts, your 401k, stocks, bonds, brokerage accounts. It also includes the cash that you have in your bank accounts and your savings accounts. And it includes your life insurance policy. So a lot of people forget to include this into your estate because it doesn't pay out until your death. Your spouse, partner, children, parents, and others that you consider your family are also part of your estate. So your estate includes things that you own and your family. I find that many people who attend these presentations, they want to learn how to control their assets while they're alive. They want to have peace of mind knowing that their loved ones will be taken care of if they ever become disabled. They want to protect their loved ones physically and financially. They also want to have control of their assets after death. So who do you want to give your stuff to, how and when? And they also want to save as much on taxes, professional fees, and court costs. So this includes avoiding probate, avoiding conservatorship, eliminating or minimizing legal fees and estate taxes. Some families want to do estate planning because they want to prevent family members from arguing over their inheritance, and they want to make sure that their wishes are clear and in writing. You might be parents with minor children, and you may want to nominate guardians for them in case something were to happen to you. Estate planning also protects the interests of special needs children and relatives. So if a person is receiving or may receive government assistance, without proper planning, their inheritance can be lost to the government, or they may be required to spend their inheritance down before they are able to receive any more government assistance. And families also want to provide a smooth transition for their loved ones and make sure that their assets are accounted for and get into the right hands. Living in the Bay Area, you see many different families from different backgrounds, ethnicities, and financial situations. So one-size-fits-all plan is not appropriate because every family is unique and different. So to help me demonstrate some estate planning options, I'm going to use this scenario. Jack and Diane are in their early 30s and 40s, and they have two young children, Ricky and Lucy. What are their estate planning options? On the screen are 4 commonly used estate planning options that we're going to be going over today. So doing nothing at all, making a will, using a beneficiary designation, or creating and funding a revocable trust. So option number 1, believe it or not, it's the most popular plan. Reports have shown 60 to 80% of all Americans do nothing at all. So when this happens, this is called dying intestate. What intestate means is that California has written a plan for you called the Laws of Intestate Succession, which is a fancy term for who gets your stuff if you die without a plan. So if you have assets that are greater than $166,250, or real estate greater than $50,000, which is everybody here in the Bay Area, your assets can end up in probate court of the county of your residence, where the probate judge decides who gets your stuff based on the laws of intestate succession. Now, there are actually some advantages to this option? Well, first, you don't have to think about dying. There's no out-of-pocket costs for you. There's no paperwork or attorney fees. So what happens when you do have to go to probate? Well, the probate process follows a specific timeline. First, you have to file paperwork with the court, and a hearing date is set. Required notice is given. Notice to the public about probate must be published numerous times in a court-approved local newspaper. In some cases, notice must be given and mailed to certain family members. Step 3, at the hearing, the court appoints a personal representative to handle your estate. So from steps 1 to 3, depending on the counties that you're in, it could take 60 to 80 days, even longer now because of shelter in place. Some courts don't even allow you to schedule a hearing date until all the paperwork is filed. At step 4, that's when your personal representative, who was appointed by the judge, needs some time to collect, inventory, and assess the value of all your assets. They might need to hire a specialist, and there also might be a probate referee that's assigned to your probate case, and that can take at least 60 days. Step number 5, you have to identify the heirs. Heirs is just a term for people who are going to get your stuff. If there are disagreements among your heirs, like who should be included and what they should get, this process will take longer. Step 6, the creditors are paid first. So they have 4 months to make a claim after the letters are issued. You cannot move on to step 7 until at least 4 months have passed from step 3. And finally, your heirs will get the distribution of your assets. So again, it's not uncommon for the probate process to take a minimum of 1 to 2 years in the Bay Area courts. It's a lot of hurry up and wait. Let's look at what the probate cost would be for a $1 million estate. So first you have a court filing fee and other forms of notices that need to be filed. So it costs about $435 to start a petition of probate and $435 to close probate. In most states, lawyers charge by the hour or they collect a flat fee for probate court, but this isn't so in California. Lawyers can charge a statutory fee. That means it's an amount based on the value of the assets that go through probate, and the percentages are set out by state statutes. For a $1 million estate, attorney fees are at $23,000. Your personal representative will get the same amount, and that's also based on California statutes. A fee is paid to the appraisers who go around and assess the assets of the value of your assets. Publication, again, is required to give notice to your creditors and family members. So if you're looking at a $1 million gross estate, your fees will be about 5% of that, or $48,000. What are some negative effects of probate? Well, first, everything becomes a public record. Everything you own, everybody you owe, who's going to be your heirs, what they're getting, their ages, where they live. And this can cause problems because it's open to the public. People can search these public records and they can look for their next victims. It also takes a lot of time, especially with current budget cuts and shelter in place. We're seeing a minimum of 1 to 2 years in Bay Area courts before your heirs get their distributions. It's also very expensive, as shown in the previous slide. And if you own property outside of California, it's possible that there may be additional or what we call ancillary probate in those states. So it's not uncommon for families to walk away from a deeded timeshare in Hawaii or Florida because of the probate may exceed the timeshare value itself. So here's a real example of what happened to Prince when he died without any estate plans. So Prince died in 2016. As of today, 4 years later, his estate is still not settled. His heirs have not received anything, but his attorneys have already collected at least $5.9 million of his $200 million estate. Another common option that people do is to make a will. Now, contrary to popular belief, a will does not avoid the probate process. In fact, having a will means that you want your estate to go through the probate process, and this is called dying testate. The process is very similar to dying intestate in California, but instead the probate judge will follow your wishes as expressed in your last will and testament. Again, if you have assets over $166,250 or real estate greater than $50,000, even with a will, you will be going to probate court. Because it has the same effects of probate, it's also going to be court supervised. That means all transfers must be approved and supervised by the court. The executor you name to handle your estate also must be approved by the judge. Your will be lodged in the county and it will be public record for anyone to view. And it still takes a long time and it costs the same. But there is a very important reason why you should have a will. So for parents with minor children, there's an important question that needs to be answered, which is, if I go home tonight and if I go out tonight and I don't come home, what's going to happen to my children? Since you cannot speak for yourself, you must do so in other ways, and a will is where you usually nominate guardianship. So what happens to your children if this happens? Well, by default, the living parent typically gets custody. If there's no living parent, then without proper planning, your children can end up in foster care for a few hours to days until an appropriate guardian is appointed. They can end up with relatives that you actually would have wanted them to go to, or with relatives that you would not want them to go to. So for my Harry Potter fans out there, I like to think of poor Harry Potter having to spend his life with Aunt Petunia instead of Sirius Black. So part of a well thought out estate plan may include naming a temporary caretaker, especially if you want to name a guardian that lives out of state or out of country and needs time to get to your children. It includes nominating a permanent guardian. You know your children best and you know who's best for your child. So it could be a relative or a close family friend. And you should also think about naming someone who will protect your child's interest. So who will manage their inheritance and use it for the child's benefit until they're able to manage it for themselves. But having just a will is not enough. So let's pretend that Jack suffered a stroke and he's unable to handle his financial affairs. Diane wanted to withdraw from Jack's IRA account to help pay for his medical bills, but discovered that she couldn't because she didn't have authority to do so, even though Jack named Diane his personal representative in his will. Well, that's because Jack is still alive and his will has no effect while he's still alive. So now Diane has to go to probate court and get conservatorship over Jack. Conservatorship is a guardianship for an adult. Sometimes it's referred to as a living probate because many of the steps that take place in probate process also take place in conservatorship process. Conservatorship has its own set of fees associated with it, which includes court investigator fees, attorney fees, and ongoing accounting fees. So how can you avoid conservatorship? One document you should have in place is called the General Durable Power of Attorney, which is a legal document that lets someone you name act as your agent, and they can manage your affairs when you aren't able to do so. Now, this doesn't always have to take place when you're incapacitated. For instance, you can use your General Durable Power of Attorney if you are traveling abroad or you just cannot manage your businesses or your personal affairs anymore. This type of document, you can cancel it at any time. You can change it, you can add to it, you can delete powers. You can also delete powers from it. An agent's powers can also include purchasing and selling a property, managing banking transactions, filing tax returns, entering into contracts, and more. This type of document is very flexible and it's customizable. Another important legal document to have is called an advanced healthcare directive. Now, this document grants power and authority to someone you name as your healthcare agent to make medical and healthcare decisions for you should you be unable to do so. It also dictates how you want your body to be handled upon your death. The last document is called the HIPAA authorization form. HIPAA stands for Health Insurance and Portability Act, which is federal law dealing with medical privacy. Sometimes this form is included in your advanced healthcare directive. You may not realize this, but even if you're married, your spouse is not legally entitled to get your medical information about you from your doctor without your express written consent. The HIPAA form tells the healthcare provider whom they're authorized to release medical information to. This is important because it helps your agent make those healthcare decisions on your behalf. You can also limit access and say who you do not want to have medical information, who you do not want to have your medical information. Another self-help planning option is the use of a beneficiary designation on various types of assets, like your life insurance, sometimes your bank accounts, your savings account, your brokerage accounts, and even your IRA accounts. When planned the right way, a beneficiary designation can be very beneficial. And it's usually an easy distribution to the named beneficiary, which is sometimes needed if there's an unexpected death. Beneficiary designations pass outside wills or trusts, which means in a will, if you say, I want everything in my life insurance to go to my child, but on your life insurance, if your beneficiary designation says your spouse, it's going to go to your spouse. Beneficiary designations also have their own set of problems. For example, when you use a beneficiary designation, you're giving up control over the use and distribution of the property in the future. No terms or conditions can usually be added to this. So your child at 18 or at a financially naive age can end up with access to a large sum of money with no guidance or protection. Life insurance could end up being paid to an ex-spouse even after a divorce if you don't take the step of removing the ex-spouse from your beneficiary designation. This is because in some states, a divorce does not automatically remove an ex-spouse from your life insurance contracts. Or you may have set up your life insurance before you were married and you named a relative, like a sibling. So upon your death, your life insurance would accidentally go to your sibling instead of your spouse. Beneficiary designation only works if you die before your named beneficiaries. So if your named beneficiaries predecease you, your assets could end up going to probate court and or go to someone you didn't want based on the laws of intestate succession. The most flexible planning option is to use the Revocable Living Trust. The Revocable Living Trust avoids all the problems that I've outlined that can or will occur using other planning options. The Revocable Living Trust consists of 3 parts. First, it's revocable, which means that you can change your mind at any time. Whatever decisions you make today can be changed, modified, or amended in the future. Second, it's living, which means it's created while you are alive. And third, it's a trust, which means that it holds property for your benefit and eventually for the benefit of others. Let's first define some terms. A settlor, sometimes known as the trustor or the grantor, I like to say anything with an OR will be you, is the creator and the original owner of the trust. A trustee is the person or persons that's in charge of the property that's put into the trust. And the beneficiary is the person who's going to benefit from the property that's put into your trust. Usually they're going to be the ones who will get the property after you die. So this next slide is a general overview of how a trust works. I like to use the analogy of creating your own company. As a settlor, you create a trust. A settlor is like the founder of a company. The trust agreement is like the company's operating agreement that tells us what the trust owns, who gets access to it, when, and how. Then you transfer ownership of most of your assets, so like your home or your accounts, to yourself as trustees of your revocable living trust. It's like putting items from one pocket to another. You name yourself as the trustee of your trust. So think of it as being the CEO of the company. And you get to run the trust and access the assets according to what you wrote in that trust agreement. When you are gone, your spouse and your children are the beneficiaries or whoever else you name, and they get to use and own the assets according to the trust agreement. When you create your trust agreement, it comes with a lot of decisions that you need to make on how your beneficiaries will get their inheritance. So should they get it in a lump sum immediately, or maybe at a certain age? Should it be staggered in increments or percentages? Or should it be held in trust for the rest of their life to offer some protection from creditors or spouses in the event of divorce? A well-drafted revocable living trust can provide for some asset protection for a surviving spouse, partner, children, or other beneficiaries. And this can be done by leaving the inheritance in a trust for your beneficiaries instead of leaving the inheritance to them directly. So why would we do this, or why should we do this? Well, you may have a beneficiary that's too young or too financially immature to handle that inheritance, and they can easily lose their inheritance through their poor spending habits and their lack of proper knowledge in investments, or to creditors. You may have a beneficiary who suffers from drug, alcohol, gambling, or other abuse problems, and they may use their inheritance to further their addictive behavior. A disabled or special needs beneficiary may find that their government benefits that they receive because of their disability may be cut off or lost entirely if inheritance is received outright. This is because most government assistance is needs-based. Receiving an inheritance directly may trigger reimbursements of benefits that they have already received and loss of future benefits. So because every family is unique and they have their own set of different situations, a customized trust plan rather than a one-size-fits-all plan is needed for these different situations. When you think of estate planning, be sure to consider having these 4 documents to ensure a peace of mind knowing that you and your loved ones will be physically and financially protected. The first one is having a trust. The second one is having what's called a pour-over will. That's a special type of will that does 2 main things. One, it acts like a cleanup document. It puts the assets into your trust that in case you forget to do so. And 2, it nominates guardians over your minor children. A third document you should have is the durable power of attorney. This is for when you're alive, but you are unable to manage your finances. And the last one is an advanced healthcare directive with a HEPA waiver. And this is to name someone who's going to be in charge of making those healthcare decisions on your behalf, should you be unable to do so. So what are some things that you can do right now? Well, the first thing that you should do is to start thinking about your estate and how you want to protect your family and children. You should also check to see who your designated beneficiaries are on your accounts and your life insurance policies. And you should identify and inventory your assets. If something were to happen to you, your loved ones would need to know where to start. I like to go ahead and tell people to go to a website called claimit.ca.gov. And it allows you to see if there's any assets that you have in California that might be just hanging out there for you to get. So for example, my brother is a former Marine. He was stationed out here in California, but he's now in Texas. He opened up an account here with Wells Fargo many, many years ago. He's now back in Texas. And he discovered that he had about $200 in his checking account here in California he forgot about that was located through claimit.ca.gov. And that's spelled CLAIMIT.ca.gov. And that concludes my presentation. And I know we had set aside some time for some questions and answers. Before we start on that, I can answer general estate planning questions, but I unfortunately cannot answer any personal estate planning questions, even if it's for a friend.
Thanks, Mary. That was awesome. In the Q&A, if you guys have any questions, please feel free to type them in the Q&A. And that way Mary can see them and she can actually answer them. And Mary, we do have one open question in the Q&A.
Okay, so the question is, can we include inheritance for yourself might incur in the future in the trust? Yes, so I'm assuming that you're saying you might inherit something from a relative, and can you include that into your trust? You sure can. We use something called an assignment for that. Okay, another one is, hi Mary, are you part of the AARG network? So that's a type of law insurance plan. I unfortunately am not part of that because I find that these plans take a lot of time to customize it correctly with a client. And the amount of money that the insurance plan pays for attorneys does not cover the time that I spend customizing each plan. How much does it cost to set up a trust? Well, it depends. So in the Bay Area, I've seen reputable attorneys charge anywhere from $2,500 to $5,000. And that should include all of the documents that I talked about earlier. And again, it also includes what type of trust. So that's one thing I didn't go over or the different types of trust that you can set up. Does a trustee have to live in the US and or be a US citizen? So it depends. No, they don't, but there are severe consequences, tax consequences, if they do not live in the US. Not so much if they're not a US citizen, and that's because if they live somewhere else, that can trigger the trust being transferred over to the country that it's being administered in, and it would be considered a foreign trust. And with that, there will be tax implications. Oh, good question. What information do we give the trustee of the revocable trust? Well, that's up to you. You can give them an entire copy of your trust if you want. Most of the time, I recommend that you just tell the trustee where your trust is located. And then upon your death, they should be able to locate that. They can certainly hire a professional to help with the trust administration, or they can do it by themselves. So an important part of decision-making when you create a trust is who to name as your trustee. The reason why it's called a trustee is it should be somebody you trust. I usually hesitate when families like to choose their trustee based on birth order, or they don't want someone to feel bad because it's a lot of work. It's basically their accountant, their CPA, plus they have to deal with families. If you don't have anybody in the US or someone that you are comfortable enough with, you can always name a professional trustee. There are individuals who do this, and there's also corporate entities like banks that also will act as trustees. And sometimes that will reduce the tension among family members. Why would everyone not go for a living trust? Well, sometimes, like you said, like I said earlier, if you have assets that are less than $166,250 and you use beneficiary designations correctly, and sometimes they allow you to do name a primary beneficiary and a contingent beneficiary in case the primary falls through, then you might not need a trust. Okay, so what happens if your spouse has already created a revocable trust before your marriage? Should we create a new revocable trust? Again, it depends. So I'm not a family attorney, but basically how you hold title, so if you own it as separate property or as community property, when you transfer it into your trust, it remains as your separate property and or community community property. So if your spouse has already created a revocable trust before you're married, it's probably all their separate property. If you're married and you don't have a prenup, it's probably going to be community property. So you might want to set up a new trust just for your community property assets. Oh, thank you, Vikram. He said it was a great presentation. Is it just a one-time thing, or we need to review the trust okay. Good question. So I always say you should review your trust every 5 to 10 years or whenever there's a major life change situation. So back in the early 2000s, a lot of estate planning attorneys, we created what's called an AB trust or an ABC trust. And that was because the applicable exclusion amount, which is basically your estate tax exemption rate, was very, very low. So up until a couple of years ago, it was maybe 1 million, 2 million, and it jumped to 5 million. Well, this year, each person can give 11.58 million to someone without having to pay estate tax. If you're married, then you can combine it together. It's called portability. So because of that, we don't need those AB types of trusts anymore because we don't have to worry about having to pay for estate tax. But now we can start planning to eliminate or minimize capital gains tax, which is the difference between having an AB trust and then what's called just having a straight, what I call an I love you trust. So upon the first death, all your assets go to the surviving trust. Whereas an AB trust is upon the first death, all your assets get split 50-50. The A trust is what's called the above the ground trust or the survivor's trust. And the B trust is called the bypass trust or the below the ground. And that's where all the deceased spouse's assets are held. And there's capital gains losses, I guess, that happens upon the second spouse's death. Can we include international funds into the trust? I don't recommend it because every country has their own set of rules. So I know in France, they have their own way of how real property will be dispersed upon your death. So you cannot include that into your US California trust because they would ignore it. Same with China. Do you need to update your living trust every time you get or sell new assets into real estate? No, you don't. Hopefully, if your estate planning attorney is able to coach you through it, they should provide you with steps on what to take if you are to get new assets or real estate. After you create a trust, you should be able to automatically put that asset into your trust without having to update your living trust. Okay, so if you're divorced with minors, is guardianship automatically granted to your ex despite naming guardians? So in most cases, it goes to the surviving parent of the child, yes. But if there's a really good reason why the other parent should not be the guardian, then you can always do a separate document to let the judge know why. Again, this has to be approved by the court. The trust holds for the whole life. Once it's set up, is it valid forever unless you revoke it? Yes, it is. Once a trust is created, how easy or difficult is it to amend that trust? It's very easy. So I'll get into more detail with that. So once you've created a trust, there's many different sections to it. So if you equate it to doing construction on your home, sometimes if you just want to update the windows, it's very easy. You just do an amendment where you just say, okay, for this section, it's now going to read this new part. But some people want to do a complete remodel of their home, and that's where we have to do what's called a restatement and an amendment. So we keep the name of your trust, kind of like your address. When you do a home remodel, you keep the address of your home, but we're going to do a complete tear down and we're going to rebuild it up again. Okay. Do trust laws differ by state? Yes, they do. And I'm only licensed in the state of California, so I can only give legal advice pertaining to California state law. Do we need to create and update trust documents in the state that we live? Again, it depends. If you create a California trust and then you move out of state, that trust is still valid. But I would always counsel the client to talk to a local attorney to see which state offers maybe a better tax benefit for you. So in California, there's no state estate tax. We have a federal estate tax, but no California estate tax. Whereas in other states, there's both. Who is responsible for dispersing the assets in a living trust if a court is not involved? That would be your trustee. So when you are alive, you are the trustee. And if it's you and your spouse, you both will be trustees. And typically upon the death of the first spouse, the surviving spouse will be the remaining trustee. And upon the death of the surviving spouse, you will be that's where you name your successor trustee. So that person will step in and they will be the ones gathering the assets and dispersing it according to your trust agreement. So it's very important that you name someone that you trust to be your successor trustee. And again, if you can't find one, there's professionals out there that are individuals and banks. And usually for individuals, they charge by the hour, kind of like a CPA. But again, it all varies. And by banks usually have a minimum, and they usually charge a percentage fee of what your estate is. So when you amend a trust or restate a trust, do you have to contact all banks, etc., and give them the amendments? No, you don't. Your trust is private. And that's the whole beauty of having a trust. You don't want anyone to know what's in it. Your trustee will be contacting the bank themselves because they will have the power to do so. And then they will be the one dispersing the assets according to your trust agreement. Now, if you write this in your will, like I want my children to have X, Y, and Z, all that will be public because your will upon your death will be lodged. Lodged means that it's sent to the county where it's recorded, it's scanned, it's uploaded, and anybody can look it up. So they'll be able to see who you've given your stuff to. So when you create what's called a pour-over will that goes with your trust, it's very simple. It's very basic. It just says, whatever I have forgotten to put into my trust goes into my trust, and that's my trust name. Here's my trust name. And also, here's who I want to be nominated. Here's who I want to nominate to be my guardians. Again, it's in your will because it goes through the court process, and the court has to appoint your guardians. So I think a lot of people have the mistaken impression that whoever you nominate will automatically be your child's guardian. That's not so, because the court has to do their due diligence and make sure that the person that you have nominated is fit to be the guardian at the time. So for example, if you nominated your child's grandparents, they might be young while your children are young, but maybe something has happened, and by the time that appointment needs to be taken place, they can't handle a teenager. So that's why it has to go through the court system. If bank accounts are part of the trust, and are banks required for a copy of a trust? No, they're not. So what you do is, once you've created a trust, you let your banks know, and you take what's called a certification of trust, and this should also be included in your estate plan. Your certification of trust is like a synopsis of what your trust is, and it's a legal document letting the banks know that you have legally created a trust. It just gives a trust name, when it was created, who created it, and who's the trustees of your trust. So then they will take most banks will be able to substitute your name. So you keep the account name, the account number, but the name changes from your name into your name as trustees of your family trust. Again, most banks do this, some banks don't. And so for me, I like to know, when I ask my clients where their banks, what banks that they are, where their accounts are, what banks they use, so that I can counsel them what to expect when they have to go through funding your trust. It's called funding your trust, putting the assets into your trust. Oh. Thanks, Henry. Henry said, great presentation, very informative, and love the movie analogies.
Mary, we have one more in the chat if you want to take a look.
Okay.
Do you have any guidance on how to convince aging parents to go through this process?
They should have been at this presentation. So unfortunately, I think when I see older parents, I see them here because they see what happened to their friends who did not set up a trust. So I know, Haneen, you're recording this, so maybe you can send this presentation.
We are going to send this presentation to everybody who signed up. So if you actually signed up and you showed up, automatically we will send you the presentation, the recording of it, by tomorrow. So you can share it with your family, friends, and everybody you feel that will benefit from it.
I should give this disclaimer to those people. This is for your educational and informational purposes only. It should not be substituted as legal advice.
I think we have one more question.
Okay.
And it popped up in
okay. Should we nominate a successor trustee right now, given that there's a possibility of both partners dying? Yes, absolutely. In fact, I have people name a first successor trustee, a second successor trustee, and if you have it, if you know, let's stack the deck. Name a third one. Remember, you can always change it. You can always amend it later. So 5 to 10 years, you might be like, okay, you know, first successor trustee might not be as available anymore. Now they moved out of the country. So let's change it and move it up.
I actually have a question, Mary.
Oh, okay, sure.
That we come across a lot with our clients. So let's say somebody bought an asset, husband and wife, and one child. And let's say years down the road, they had a second child. So now the ratios of the trust distribution are going to change, not dramatically, but they are going to change significantly. how does it work if, let's say, if you have a second child and you're amending your trust, is that considered, with your analogy, is that a remodel or is that a rebuild?
So again, it all depends on who drafted your trust. For me, if I know my clients there might be a possibility of having a child in the future, I always include the clause in there that if there's another future child, this is how the trust will go. But if the distributions are the same, if they still want each child to be receiving, like a child at 25, they want them to get 25% at 30, one half at 35, the remaining, they can just do a quick amendment. But typically your trust should be robust enough to account for future children.
Got it. And now what happened if you adopted children? Is it treated the same if they're adopted and
Yes.
not biological?
Good question. Yes, it is. Yeah. And then there's another question that says, can your successor trustee automatically start accessing your assets, or can we include a trustee at a later time? Oh, they only have access to your assets when they are trustee. So as long as the both of you are alive, they're not the trustee. They're just waiting in the wings. Only upon the death of the second of you, then they step into their trustee, and then they can access those assets. That's a good question.
Well, Mary, I just want to say thank you so much for your time, and thank you everybody who attended. We are so thankful and grateful, and we hope you found it very informative. From everybody at Henning Hayter and Associates at Compass, and Mary, we want to thank you, for making the time during your busy day. And Mary, where can somebody find your contact info in case they want to reach out to you and start this conversation?
Sure. Do you mind if I share the screen again?
No, of course.
Okay. Okay. So I think you should be able to see my contact information. I'm located. My office is in San Mateo, but currently it's at home in Millbrae. But please feel free to email me or call me, and we can set up a consultation. I'm always happy to help your clients.
And I'm so thankful for you, because we had few clients of ours that were, in the medical field, and they needed to get few things done. And Mary went out of her way to get it done for them. So we are thankful and grateful for you.
No problem. Yeah. What Henning is referring to is we've been doing what's called contactless signing, where it's like I stand behind a glass. But everything is signed, everything is executed.
So thank you. We look forward to talking to you soon.
Thank you.
Thanks everybody for joining.
Thank you.